Hello and welcome to this video on rules governing writ proceedings, which is part of our final unit in the advanced program on civil drafting for practicing advocates. Hi, I'm Richa Kaur. In this video lecture, we'll explain the rules that govern drafting of writ proceedings.
Hi, I'm Aditya Narayan. As you would be aware, writ proceedings arise before the High Courts under Articles 226 and 227 of the Constitution of India. The parties to a writ petition are called the petitioner and the respondent. The petitioner is the party who seeks the writ from the High Court, and the respondent is the party against whom the writ petition is filed. While state-specific rules imply divergence in the forms of writ petitions across states, a writ petition will normally comprise of the following elements: an index, a synopsis containing a list of dates and events and a brief statement of the facts; the memorandum of writ petition, a verifying affidavit; the documents accompanying the writ petition; and a wakalat. The index contains the short cause title of the case and a table detailing the various papers that are filed by the petitioner into the court. The short cause title is set out as in a plain document, that is, list out the name of the court, the case number and year, and the name of the first petitioner and the first respondent. After the cause title and under the heading index, list out the documents that form a part of the paper book as follows: the synopsis, the memorandum of writ petition, the verifying affidavit, the documents produced in support of the writ petition, and the wakalat. The documents must be placed in the order in which they find reference in the writ petition and numbered serially as annexure A, B, C, and so on and so forth. Immediately after the index comes the synopsis. The synopsis is composed of two parts, that is, the list of dates and events and the brief facts of the case. The list of dates and events should set out in a chronological order all relevant events. The statement of facts is a brief summary of the facts on which your case rests. Remember that a busy judge might take the shortcut of reading the synopsis before coming to court. It is therefore crucial that you should craft your synopsis carefully to highlight the important aspects of your case. The memorandum of writ petition itself contains several elements as follows: the cause title, the heading, the body of the writ petition, and the prayer column. The full cause title, like in all other pleadings, will state the name of the court, the case number and year, and the names, addresses, and ranks of all parties. The heading will state that the document is a memorandum of writ petition and identify the provision that it has been filed under, that is, Article 226 or 227 of the Constitution of India. It has become common for lawyers to cite both provisions in writ petitions. When you believe that Article 227 has application, you may do so. The body of the writ petition will contain a statement of the background facts of the case, the grounds on which you seek the writ from the court, and the usual procedural pleadings. Where you are seeking interim relief from the court, you should set out immediately below the grounds for main relief and under the heading grounds for interim relief the various grounds on which you are seeking such relief. After that, set out your prayer. Remember that since historically the remedy did not follow the right, it is customary to couch the prayer for a writ in the broadest terms possible. Therefore, for example, when we are seeking for a writ of mandamus, we request the court to grant a writ of mandamus or a writ, order or direction in the nature of a writ of mandamus or such other writ, order or direction as the court may be pleased to grant, and then describe the action or order against which the writ is being sought. Immediately after the prayer column, set out the interim prayer if any is being sought. It is sufficient for the writ petition to be signed by counsel. The writ petition is accompanied by a verifying affidavit, which is similar to that in a plaint document or appeal, subject to relevant changes to reflect the changed nature of proceedings. As stated above, set out immediately after the writ petition the various documents in the order that they are referred to in the writ petition. It is considered good form, although not necessary, that a document that you are challenging before the court, such as a court order or government notification, be produced as the first annexure to the memorandum of writ petition. After the various annexures that you have filed, attach the wakalat that has been granted in your favor. It is normally customary that the original or certified copy of the document that you are challenging is produced after the wakalat. It is also considered good practice that in the first paragraph of the memorandum of writ petition, you introduce the nature of your grievance and specify the identity of the document that you are challenging before the court, if any. If you are appearing in opposition to a writ petition, you will have the occasion to file a statement of objections in writing to the writ petition. In the statement of objections, use throughout the short cause title, and under the cause title, set out the heading of the document as statement of objections. Identify the respondent on whose behalf it is being filed by his rank in the proceedings. Set out consecutively all objections to the petition and conclude with a prayer that the court be pleased to dismiss the writ petition. A verifying affidavit similar to that contained in the writ petition should accompany the statement of objections. Such documents as you are relying upon will follow the verifying affidavit and be numbered consecutively. The serial number of the document is preceded by the letter R where there is only one respondent, and by the rank of the respondent where there is more than one respondent. Therefore, for instance, documents produced by the first respondent will be marked as annexure R11, R12, R13 and so on and so forth. You will find more details regarding marking of annexures in the related reading materials. So far, we have gone over the rules governing drafting of memoranda of writ petition and statements of objections. Before concluding, we will briefly review the rules that govern drafting of interlocutory applications in writ proceedings. The application will contain a full cause title with an additional column to show the ranks of the parties in the application. Where the application is a detailed application, set out the grounds on which the application is made, followed by the prayer. Where it is a formal application, it will take precisely the same form as an application in civil proceedings. These affidavits will adhere to the rules that we have seen in Unit 4 on affidavits. This concludes our last session on civil pleadings. Over the course of this program, you would have got an overview into the various documents that are used in civil proceedings before courts in India and the rules that govern the form that these documents take. Remember, however, that these generic principles are subject to change from time to time, and be sure to check with your local rules and effect such modifications to these drafts as may be required. This brings us to the end of this last video on this advanced program on civil drafting for practicing advocates. Thank you for watching.